Judicial Lexicon. That is the words, judicial words that are just predominantly used in the Nigerian legal system, in the Nigerian legal jurisprudence, in our normal day-to-day court practice or the legal parlance, as depending on how you understand it. This is Lawyers Info Hub. You're welcome. You go. I do thank returning subscribers, and if you're yet to subscribe, please hit the subscribe button. I want to sincerely thank all my subscribers. It's been an amazing journey. From one subscriber to now we are in thousands. I'm very grateful. So we're going to just look at some legal words today and explain their meaning. Yeah, this platform is just to support the legal education, support you who is watching, to become a better lawyer and to become better in whatever you are doing. So the first the words we're going to talk. So let's talk about burden of proof. Basically, the phrase burden of proof, it has three meanings. We have the persuasive burden, which is the burden of proof as a matter of law and pleading. That is the burden of establishing a case, whether that by preponderance of evidence or beyond reasonable doubt. That is the legal burden of proof. We also have the evidential burden. Yeah, the evidential burden, the burden of proof in the sense of adducing evidence, and we also have the burden of establishing the admissibility of evidence. So when we talk about burden of proof, it has three meanings. The persuasive burden, which is the burden as a matter of law and pleading. We have the evidential burden, and we have the burden of establishing the admissibility of evidence. Yeah, so let me just cite a case here so that you can read it up. The case of UBN PLC against Ishola is a 2001 42 WRN at 77 or 2001 15 Nigerian Weekly Law Report, part 735 47 at cause of action. What is cause of action? The fact, or is a combination of facts which gives rise to the right to sue. Those facts that accumulate to, giving someone right to sue. Is a right to the right to sue. It consists of the wrongful act of the defendant, which now gives the plaintiff the right to now complain, and the damage which is consequence of the wrongdoing. Now let's look at cause of action extopel, also known as issue extopel. Cause of action extopel is here. It precludes a party to an action, the agents, the privies, from disputing as against the other party in any subsequent suit, matters which have been adjudicated upon previously by a court of competent jurisdiction between him and the adversary involving the same issues with regards to issue extopel. When a matter, some issues in a matter have been resolved, and there's a need for the the matter is maybe reinstituted for another issue, issue, by the by issue extopel, parties are extolled or precluded from raising those issues which has been adjudicated upon by a court of competent jurisdiction. Now, when you hear the word charter party, what does it mean? It usually consists of a signed contract embodying the terms already negotiated and agreed by parties or their agents. So a charter party usually consists of a signed contract embodying terms already negotiated and agreed by parties or their agents. So when we hear the word chattel is just movable or transferable property, especially personal property. They're either personal chattels or real chattels. Personal or real charters. Then when you hear the word condition precedent, it's that thing that must be done or which happened in a particular case before a person is entitled to sue, despite having a prima facie right of action. Is a condition precedent, something that must be done or which must happen before a person is entitled to sue. You say this is a condition precedent. For example, maybe parties in a contract and agree that where there is an issue in this contract, we have to, pass through arbitration before we head to the court. So where there's an issue and they bypass it, someone can bring an objection that, see, we during our negotiation or in our contract states that arbitration has to be, utilized before we can head to court. So that will become a condition precedent before the court can can have or is seized with the jurisdiction. So I'm just using that as an example. Is a thing that must be done or which must happen in a particular place in a case before a person is entitled to sue, despite even when the person has the prima facie right of action. So it's very important. Then what is consent judgment? Consent judgment is that judgment, which wherein parties have agreed, consequent upon terms of settlement. The court will now, based on the agreement upon the terms which have been released in writing, now make it a consent judgment. Then what is a consequential order? A consequential order is an order that that necessarily flows directly and naturally from inevitable let me just say it again. It's an order that necessarily flows directly and naturally and inevitably consequent upon it. It must be given effect to the judgment already given. Now let me explain it. Consequential order. Where in a judgment, peradventure, someone is being owed maybe 3 million and the judge has ruled that I am satisfied that by evidence before me, the defendant is owing the plaintiff 3 million. Now, for one reason or the other, maybe the defendant has money somewhere which are presented to the court. See, I have this money, but I can't pay or something. Now, the court might make a consequential order which will flow from the judgment that having ordered that the defendant is owing the plaintiff. The court will now say, maybe within 30 days from this judgment, the defendant shall rise to maybe the bank to release his money for which he will now use to pay the claimant. I'm just using that as an example. So that consequential order must flow from the judgment. It is an order that gives effect to the judgment. It's something that helps, that gives effect, that stamps the judgment. It's an order following a judgment, but it must actually flow from that judgment to give effect to the judgment. Now look at confessional statement. Confessional statement is an extrajudicial statement made by an accused person to the police containing assertions of admission showing that he participated in the commission of the crime or the offense which he stands as the accused. Now, what is consolidation of action? It's a process whereby two or more actions that are pending in the court are by the order of course joined together or tried together at the same time. Maybe two sister cases or two similar suits are pending in court. I thought, like, why do I waste time trying each other or hearing the two? Let it, by the order of course, it will be consolidated and heard by the same time. It is important that this though the action may be those separate and distinct, they can still be tried together. Maybe there's something, there's a linkage that needs them to be tried together, and it saves judicial time. It saves judicial time. So the court will not make an order. There must be an order before that consolidation. Now, what is contingent? When the word contingent is used, it just means like the proportion that falls to one in a division as to a share to be contributed. Or you can say the contingent upon which This word contingent is usually used in winding up petitions, though it can be used elsewhere, but most times, with respect to winding up petitions, it means the proportion that falls to one in a division as a share to be contributed. Now, let's look at the word damages or damage. Is defined as a disadvantage which is suffered by a person as a result of the act or default of another. This is damages. It's a disadvantage which is suffered by someone because of the wrongdoing or the default of another person. Now, when the word damages is, I've defined damage. Then when the word damages is used, damages is a pecuniary compensation or an indemnity which may be recovered in court by a person who has suffered loss. So we have damage, we have damages. So we define damage as a disadvantage which is suffered by another person that is caused by the default of that other person. Now we have looked at damages as pecuniary compensation or indemnity which may be recovered in court by a person who has suffered loss, injury, detriment, whether to his person, to his right, to his property, So that is damages. Now look at debenture. What is debenture? Debenture is a company's security for a monetary loan. Company's security for a monetary loan. It usually creates a charge on the company's stock or property. Now, when you hear the word damnation injuria, it means that before damages can be recovered in an action, there must be wrong committed. It's a Latin word, damnation injuria. Before damages can be recovered in an action, there must have been a wrong. Now let's look at the decision in limine. Decision in limine means a decision in limine is one at the very beginning or at the threshold. A case decided or terminated without taking evidence or hearing witnesses. We say this was a decision in limine, a decision that is, given without hearing witnesses or taking of evidence. Now, decisions can also be given per incuriam. Means those decisions were given in ignorance or forgetfulness or some inconsistent statutory provisions or some authority binding on the court concerned. So when decisions are given per incuriam, means they're given in ignorance or forgetfulness of some statutory provision or some authority binding that court concerned. So when we hear the word declaratory or the words declaratory judgment, when the claimant is in doubt as to judges the respective rights of the parties and then proceeds to order the defendant to act in a particular way. The court has, declared the rights of the party and now makes an order for the defendant to act in a particular way, either to refrain from interfering or refrain from doing an agreement is a statutory remedy for the determination of a justiciable controversy, where the defendant is in doubt as to his legal rights. See, in a case where you could see there's some claims where the court would now say an order that the claimant is entitled to do this. At that point, the claimant is in doubt of, do I really desire or do I really need to have this? So a declaratory judgment kind of reinforces the rights of a party who is in doubt. So this is just the literary understanding. What is deem? When the word deem is used, D-E-E-M, it means to hold, to consider, to adjudge, to believe, condemn, determine, or treat as if, or to construe, to deem something. We have a deeming order and all of that. So to deem something, to consider something, to adjudge something. Now let's look at the word defamatory imputation. Defamatory imputation. is an imputation which may tend to lower the plaintiff in the estimation of the right-thinking members of the public. Defamatory imputation. An imputation which tends to lower the plaintiff in the estimation of the right-thinking members of the society, which exposes him to hatred, contempt, ridicule, and all of that. So then what is default judgment? You see that default judgment is a judgment for the plaintiff, which means it is obtained by the defendant's failure to comply with the rules of the court. So it just solely judgment obtained solely on default of pleadings or non-compliance by the rules of procedure by the defendant. Now look at defense on the merit. Defense on the merits is under the undefended list procedure. A fact or facts indicating a defense on the face of it. That's defense on the merit. It encompasses a defense in law as well as on facts. When the word delegatus non potest delegare is used to talk about a delegate cannot subdelegate. Where a power is delegated to someone, it is exercisable by that person directly and personally, and the person lacks the legal power to redelegate such power. Is a very key principle of the delegatus non potest delegare. It's very important. Now, let's look at the word due marriage. Due marriage, money is money payable to the owner for delay to which the owner is not responsible. Maybe sometimes in loading and discharging after the laydown time has expired. Due marriage, like the normal balance where someone, you're supposed to, maybe someone is supposed to pay you for, or let us use for a truck that is discharging goods. You're expected to be in port, or for example, in any place for 3 days. After that 3 days, they start charging you for overstaying. So that's just literally the meaning. So we have the word de novo, means starting from the beginning, starting afresh. Now we look at what is a derivative action? It's an action that is brought by a shareholder in the name of himself and all other shareholders to enforce the company's right. That is a derivative action. Action that is brought by a shareholder in his name, by himself, and for all other shareholders to enforce the company's right. Now we look at our desirable parties. Who are desirable parties? Desirable parties are those who have interest or who may be affected by the action or the result of an action. These are desirable parties who may be affected by the result of the action. Now let's look at detinue. What is detinue? Detinue is a jarring of threat of trespass to goods, and it occurs when a party cites as the defendant fails or refuses to return or give up possession of a chattel to the owner after the owner has made demand for it. I've refused to give the owner back his property after the owner has made demand for it. We are really trying today. So let's look at just the word disclaimer. Disclaimer. In this ordinary meaning, it means denial or renunciation. Denial or renunciation. Now let's look at non-suit. When you hear the word non-suit, what does it mean? Non-suit. Now, an order for dismissal puts an end to the claim and creates estoppel parem judicatum against the plaintiff. But that is for dismissal. When an action has been dismissed, it's different from the issue of non-suit. Now, when there's an order of non-suit, it means the plaintiff is given a second chance to prove his case. It usually means have a second bite at the cherry. Sometimes you've seen cases where a judge will ask, by the orders of rules of court, and said, I feel plaintiff, you've not proved your case, so come and prove your case again. Do you have further documents? The other things? So in some instances it happens. So that's the non-suit order. When the court says, come and have a second bite at the cherry. Come and have a second bite at the cherry. why the order of dismissal puts an end to the claim and creates that estopere perem judicatum, where it ends the matter. If you want to go about it, you go. If you want to, you just have to appeal if you're not comfortable with it. Whereby the issue of non-suit is different. Just come and have a second bite at the cherry, because the court is of the opinion that the plaintiff has not proved his. So the doctrine of laches and acquiescence, but laches means is a delay that which is sufficient to prevent a person or a party from obtaining equitable remedy. This under the doctrine of laches and acquiescence, it means maybe where someone is just staying there last. Something is going on environmental on your land and you failed to do something, is a delay that is sufficient to prevent a party from obtaining an equitable remedy. You were there, you have a land, someone is been on your land, you didn't do anything. I'm just using that for example. So that's when you say someone is guilty of the doctrine of laches. Now, what is duty of care? We're going to end with that. Duty of care, it means taking reasonable care to avoid acts or omission which can be reasonably foreseen, which will likely injure another person. So when you say the person should have duty of care, it means taking reasonable care to avoid those omissions which can be reasonably foreseen or would likely injure another person. So look at the case of Anya and Imo Concord Hotel. I know the locus classes in Donahue and Stevenson. Anya and Imo Concord is a 2003 for WRN or a 2002 18 Nigerian Weekly Law Report, part 799377. So, friends, we've been able to look at some Nigerian legal Judicial Lexicon. Yeah. So, I think I'll have great time again to do more. There are a lot of phrases, words that we need to know as lawyers. Now, let me use this as a surplus. When error in law, what is an error in law? It's only used in the appellate practice. It's an allegation by the appellant that there is a failure of the lower court to apply the correct principles of law to establish an undisputed fact, or that the court has come to a conclusion, without applying the principles of law. So when you see where someone is preparing a notice for appeal, those grounds of appeal, and say there's an error in law, it means that the lower court did not, apply the correct principles of law to establish or reach at that decision that it reached. So, friends, it's been a nice time this afternoon, this day. Yeah, I wouldn't know when you were watching it. It could be day, or it could be evening, it could be afternoon. But it's been a nice time. Hope you learned something. Just try to do what you can do to keep growing, keep getting better, because the top is tough and it is only meant for those who are prepared. Do take care and have a nice time.